Hello viewers, welcome to the channel Scientellectual. In the current video, we are discussing 4 more sections under chapter 16 Working of Patents, Compulsory Licenses and Revocation. The sections are 85, 86, 87 and 88, and we are discussing the relevant rules, forms and fees as well. First, we are discussing section 85. Revocation of patents by the controller for non-working. Subsection 1. In respect of any patent, a compulsory license, if it has been granted, then after expiration of 2 years from the date of order of grant, the first compulsory license, the central government or any person interested may apply to the controller for revocation of that patent. And the ground for revocation would be patented invention has not been worked in India, or reasonable requirement of the public with respect to the patented invention has not been satisfied, or the patented invention is not available to the public at reasonably affordable price. Section 85, subsection 2. Now, every application under subsection 1 shall contain such particulars about the facts upon which the application is based. That is why the revocation is requested. And in case of an application other than by the central government, it shall also set out the nature of applicant's interest. Why applicant is applying for revocation of the patent. Subsection 3. The controller, if he is satisfied that the reasonable requirement of the public with respect to the patented invention has not been satisfied, or patented invention has not been worked in India, or the patented invention is not available to the public at reasonably affordable price, then he may make an order for revoking the patent. Subsection 4. Every application under subsection 1 shall ordinarily be decided within 1 year of its being presented to the controller. Now let's come to section 86. Power of controller to adjourn applications for compulsory licenses, etc. in certain cases. Subsection 1. When an application under section 84 or 85 is made and it is on the ground that the patented invention has not been worked in India, or the ground that is mentioned under subsection 7d of section 84, and if the controller is satisfied that the time which has been elapsed since the sealing of the patent, that is grant of patent, has for many reasons been insufficient to enable the invention to be worked on commercial scale to an adequate extent, or to enable the invention to be worked to the fullest extent that is reasonably practicable, then he may adjourn further hearing of the application for such period not exceeding 12 months in aggregate as appears to him to be sufficient for the invention to be worked. That is, when under section 84 or 85 the application has been made and the application ground may be that the patented invention is not worked in India, or maybe the ground which is mentioned under subsection 70 of section 84, which has been discussed in our earlier video. And if the controller thinks that the time which has been lapsed after grant of patent, there is sufficient cause not to enable the invention in commercial scale in India, then he may give a chance to make it worked in India, and he may adjourn further hearing of the application and give extension of time maximum of 12 months to work the invention in India. Section 86, subsection 1 continues. The adjournment that has been mentioned in subsection 1, it is in that case, it is provided that in any case where the patentee establishes that the reason why the patented invention could not be worked before the date of application was due to any state or central act or rules or regulations or order of government imposed by way of condition for the working of invention in India, or for the disposal of patented article or article made by the process, or by the use of patented plant, machinery, apparatus, etc., then the period of adjournment will be counted from the date on which the period during which the working of the invention was prevented by act, rule, regulation, or order of the government as computed from the date of application expires. That is, adjournment is possible in the ground that when patentee establishes that why his patented invention was not able to be worked in India, if the cause is any imposing of central or state act, rules or regulations or order of the government giving any condition for working of patented invention in India, or disposal of patented article or process. In that case, that is, by some reason of imposing those act, rules or regulations, he was not able for the patented invention to be worked in India, then he may get the adjournment for hearing, and that period of adjournment will be counted from the date on which the period during which the working was prevented as computed from the date of application expires. Section 86, subsection 2. No adjournment will be ordered unless the controller is satisfied that the patentee has taken any prompt, adequate, or reasonable steps to start the working of the invention in India on commercial scale and to adequate extent. That is, patentee needs to prove that he has done all the necessary actions for the invention to be worked in India. If he fails after prompt, adequate, reasonable working, then only controller will think for adjournment of hearing. Let's come to section 87, procedure for dealing with applications under section 84 and 85. Subsection 1. If the controller is satisfied upon consideration of an application under section 84 or 85 that the prima facie case has been made out for the making of an order, then he shall direct the applicant to serve copies of the application upon the patentee and any other person appearing from the register to be interested in the patent in respect of which the application is made, and he shall publish the application in the official journal. Section 87, subsection 2. Now the patentee or any other person desiring to oppose the application, that is opposing the compulsory license application, then he may give notice of opposition to the controller within prescribed time or further time if the controller allows. Subsection 3. If the patentee gives the notice of opposition, that notice will contain statement setting out the grounds on which the application is opposed. That is why patentee is requesting for opposition. Subsection 4. If the notice of opposition is given, then the controller shall notify the applicant, that is, the application made by the applicant for compulsory license, and patentee is the patent holder of that invention. The controller shall notify the applicant and shall give the applicant and the opponent an opportunity to be heard. That is, both of them will be called for hearing before the controller decides the case. Section 88. Power of controller in granting compulsory licenses. Subsection 1. Say an application is made under Section 84, that is application for compulsory license. Now the controller, if he finds that the manufacture, use or sale of materials not protected by the patent is prejudiced by reason of conditions imposed by the patentee upon grant of license under the patent, or upon the purchase, hire or use of the patented article or process, he may, subject to the provision, order grant of license under the patent to such customer of the applicant or to the applicant. That is, when compulsory license application has been made by the applicant and after that controller finds that the patentee, the patent holder of the patented invention, is giving unnecessary terms and conditions for which the applicant is having problem for working the invention, and patentee is imposing some conditions which is not related to the patented invention, rather it is related to some other patent, then in that case the controller will give the license of that other patent also to the customer of applicant or applicant, so that he can work on the patented invention to the fullest extent. Subsection 2. Where the application under Section 84 is made by a person being holder of a license under the patent, that is, he is already having the license under that patent, and controller, if he makes an order for the grant of a license to the applicant, that is, the applicant is already having a license under the patent and still he is applying for compulsory license of the patent. In that case, the controller may cancel the existing license or may amend the existing license. Where two or more patents are held by same patentee and an applicant for compulsory license establishes that reasonable requirement of the public have not been satisfied with respect to some only of the said patent, then if the controller is satisfied that the applicant cannot efficiently or satisfactorily work the license granted to him under those patents without infringing the other patents held by the patentee, and if those patents involve important significant advancement of considerable economic significance in relation to the other patents, then the controller may direct grant of license in respect of other patents also to enable the licensee to work the patent to which license is granted under Section 84. Say a patent holder has two or more patents. An applicant has been granted compulsory license for one of them. Now, while working on that patented invention for which he has been granted the license, he is experiencing that other than those other patents, he is not able to work the licensed patent to the fullest extent. That is, efficiently or satisfactorily, he is not able to work only based on the patent for which he has been given the license. He needs the other patent's license also. In that case, if those other patents involve important technical advancement, economic significance in relation to other patents, then the controller may direct grant of license of the other related patents also to the applicant so that he can work to the fullest extent. Subsection 4. Where terms and conditions of a license has been set by the controller, the licensee may at any time after he has worked the invention on commercial scale for a period not less than 12 months, make an application to the controller for the revision of terms and conditions on the ground that terms and conditions set have proved to be more onerous than originally expected. And as a consequence, the licensee is unable to work the invention except a loss, provided no such application shall be entertained second time. That is, terms and conditions of voluntary license is set by the parties. But in case of compulsory license, terms and conditions is set by the controller. Now, whatever terms and conditions has been set by the controller, now during working of the invention, the licensee finds that it is not very profitable for him. He is experiencing loss or it is more onerous than he expected. Then, after 12 months of working of the invention on commercial scale, he may apply to the controller to revise the terms and conditions. But this will be done only one time. Let's discuss the relevant rules and forms, and fees will be discussed also. The relevant rules are Rule 96, which says about the application to the controller for an order under Section 84, 85 and later on 91, 92, 92A shall be made in Form 17 or Form 19, whichever case suits. Rule 99 says about the manner of publication for the revocation order. Rule 98 discusses about notice of opposition under Section 87(2). Rule 100 deals with the application under Section 88(4). It says that for the revision of terms and conditions of a license which have been settled by the controller shall be made in Form 20. Rule 101 deals with procedure to be followed in case of applications made under Section 88(4). Here are the forms with relevant fees as per first schedule under Indian Patents Act 1970, which are related to the sections discussed in this video. Thank you all the viewers for watching the video. These sections are very important under Indian Patents Act 1970 and the other videos as well which we are covering under Indian Patents Act 1970, providing all the necessary informations regarding sections, forms, fees, rules, etc. will be very beneficial during the preparation of Indian Patent Agent exam. Thank you all. If you like, please give a like and please share and subscribe the channel Scientellectual. Thanks again.